first meetup of the month. We're going to meet again in the end of September. That will be like September 26th timeframe. And the speaker is to be announced, so make sure you show up for that one. But we are going to have Bruce presenting today. He is a real estate attorney. He's helping me out with some of my own financing stuff that I've done on my fourplex. So if you have any questions or topics you want to start with, definitely let him know. That will be a good time to questions answered. So everyone, give it up for Bruce.
Attorneys don't handle applause real well. So I'm Bruce Rands. A little bit about me. I've been an attorney for 24 years here in Colorado Springs. I spent the first 10 years of my career as a deputy district attorney, prosecuting in law enforcement. The last 14 years, I've been in private practice. I'm a partner at Robinson and Henry, just located in the old Holly Sugar building, the First Bank building. I've been there only about 4 months. I was a partner at Torbett, Tufts & McConkey for about 12 years. So I handle, my title is civil litigation partner, so I handle courtroom things, but I also do contracts, property law, a lot of those sorts of things. I have a broad client base. I've been doing trials for 24 years, so I've seen a lot of interesting things about real estate, and my goal was to just answer some of the questions you have. You know, we typically, attorneys, we bill for our time, and so sometimes we're pretty inaccessible at $500 an hour. So if you got questions, there was already a question about corporate structures. So if you've got a partnership, so a partnership defines kind of a relationship, but it doesn't necessarily, it's not a solid corporate structure. So you don't want to go into buying real estate in a partnership. You want to have some more formal structure, like a limited liability company, an LLC, a C Corp, an S Corp. You want to have some sort of structure. There's a few reasons for that. Number one, you want an operating agreement. If it's a limited liability company, you have an operating agreement. That operating agreement outlines the duties of all the parties with respect to the investment, with respect to each other. It apportions ownership interest, and it talks about things that could go wrong. So what happens when a member withdraws? What happens when a member dies? What happens when a member gets divorced? What happens with all these eventualities? That's largely what the legal field is for preparing for things that people don't think of, they don't want to think of, and so that's a huge problem that I see. I've got clients that had a $22 million a year company, and their operating agreement was basically on the back of a napkin. That doesn't work, and so when something happened that they weren't expecting, now we're in year 4 of litigation on that, and so. And you can expect, I did a trial a couple of years ago on an operating agreement gone bad, a partnership in a restaurant, and the legal fees were over $200,000. So it does cost to get those set up at the front end, but not nearly as much as it costs to litigate them on the back end. So build that into your costs for startup. Is, okay, what structure are we going to have? Same thing if you're a landlord. A lot of landlords have very informal leasing structures. That's okay as long as everything is going well. But when things don't go well, then that informal leasing structure becomes a problem. So I would recommend that you have a set written out lease that clearly defines the boundaries, clearly defines the terms, and limits your liability. So it's going to have some common clauses. For example, in Colorado, you're not entitled to recover attorney's fees unless it's a part of the contract. So you can't come in and say, I want to recover attorney's fees. Well, if your contract doesn't allow you to recover attorney's fees, unless there's a statutory provision that allows it, you don't recover attorney's fees, which means litigation is really expensive and there's no hope of getting that money back. We see that a lot in construction defect cases. So most construction contracts will not have an attorney's fee provision. If you've done a construction contract, they're often just bids. So you'll get a contractor out there, he'll say, oh yeah, I'll run a water line, here's my bid, it's gonna be $1,500. And the bid sheet becomes the contract. That's legal, it's legally binding, but that bid sheet probably doesn't have an attorney's fee provision. It probably doesn't have deadlines. It probably doesn't have all of the legal protections that you'd need in order to sue under that contract and recover. So when things go south and you want to sue, I handle a lot of consultations of people say, well, I want to sue. And I said, okay, if your case is under $40, $50, $60, $80,000 and you don't have an attorney's fee provision, any money that we get for you is likely coming to us first and not you. So people are unhappy with that. And I don't want to put clients in that position. So you really want to make sure that you have a solid contract before you enter into things that protects you in the long run. Those construction defect cases, most don't have an attorney's fee provision. And so I tell the client, look, if we have to litigate, I've spent hundreds of thousands of dollars litigating construction defect cases. If there's no attorney's fee provision, whatever you spend to me, let's say it's a $10,000 fix and you spend $5,000 in attorney's fees, you get $5,000 to fix a $10,000 problem, you're not happy.
Sorry, don't mean to interrupt you, but I just have a quick question. So you were mentioning having an LLC some sort of protect you, and you mentioned having a solid lease agreement, things like that. Is there any issue with retroactively having those things in place? Let's say you buy a house and then you form an LLC afterwards,
Yeah.
or you get a tenant and then create a lease after they're already moved in. Like, what are the issues with that?
Asking for a friend, I know. So there are some issues that you need to be aware of. So if you purchase a house, one of the clauses in your mortgage, if you have a mortgage, if you pay cash, this isn't a problem. But if you're like most people and you have a mortgage, one of those clauses is what's called due on transfer or due on sale, which means if you transfer the property to an LLC, the bank can call your note and make it due that day. Generally, it's within 30 days. But so you don't want to trigger that. Now, most banks will work with you if it's a single member LLC or a double member LLC with like a husband and wife. They don't have a problem with you transferring from your personal liability to the LLC as long as you clear it with them beforehand. But if they suddenly see a deed comes across that's recorded where you're transferring the property to number one LLC, they say, they just transferred the property. Our note's due. We didn't get paid. We're going to go collect our note. So there can be some issues with doing it retroactively. You just have to cover yourself. Talk to your lender. Talk to your insurance company. Make sure that those people are prepared for that transfer. The insurance can be a real big problem. If you've got a residential policy, but it's being used as commercial, they can deny coverage. So if one of your tenants starts a house fire, suddenly you don't have any coverage. So that means you've got just dirt left.
What would incentivize them to call on your note? Because they make a lot of money off of, money.
They do, except think about interest rates. If interest rates change, lenders become very hesitant. If they can get another note at a higher interest rate, they'll force you into that higher interest rate. So they're your friends when interest rates are low, and it's like, yeah, no problem. But if they see, we have this all the time in this area, a lot of military guys will buy a house with a girlfriend, and then they break up. Well, when you buy a house, you get two ownership interests, right? You get the deed, and you get the mortgage note. Well, the deed, you can just deed the property away with a quitclaim deed. So you can just sign a piece of paper. So you buy the house together, you break up, ex-boyfriend can just sign the house over to the girlfriend. The problem is on the note. The bank is unwilling to let a guarantor off the note. Well, I'm not going to sign over my ownership interest in a house if I'm still obligated under the note, because the note survives. Even if I don't own the house anymore, I still owe the debt. So banks, when interest rates have changed, I had a case a couple years ago where interest rates had gone up, and the bank said, well, we're not going to allow her off the note. You're going to have to refinance to get her off the note. Well, because interest rates were higher, the banks were forcing him to refinance because they got a higher interest rate. So that's where it can become tricky after the fact is the banks have you over a barrel. It's like, well, you know, you want off the note, you got to refinance. You want to refinance, you're going to pay, your payment's going to go up $500 a month. Those are the types of things where it's helpful to deal with it beforehand. If they had had a contract beforehand, then it would have saved them a lot of time and money.
What can you tell us if we get into an eviction situation?
Okay, evictions have gotten really complex in the last 2 years. For example, I used to charge $500 flat fee for an eviction. Now I wouldn't touch one for under $2,500. I wouldn't even consider it, and I'd do it hourly. The reason is that the state has gotten progressively more pro-tenant. So when you do an eviction, you have to really look at your notice requirements. You have to look at your security deposits. Are you holding your security deposits in a trust account? Meaning they're separate from everything else and you can identify those funds. Are you returning those funds within 30 days or as your lease dictates, no more than 60 days? If you don't return them, they will sue you and get treble damages. So they'll get 3 times their security deposit back. And you have to return them with a list of what you deducted for. So when you go through an eviction, let's say you've got a tenant, number one, you can't just evict them because their lease is expired anymore. They just passed that law, which is crazy. I don't think it's constitutional, but it's the law right now in Colorado, where you can't just say, I don't like you, I don't want to rent to you anymore. You have to say, there has to be several different reasons. I'm going to occupy this property myself, I'm going to sell the property. There has to be some other reason than just, I want you out. You serve them the notice. If they've had a tenancy for over a year, you're looking at 91-day notice.
Maybe the tenant has a bad behavior or he's messy or he just doesn't, he's not a good person overall. What would happen? Still a no-go? That's a no.
You've got to have a reason. They've got to have violations of the tenancy. They've got to have, there is a legal clause for substantive violations, but that's generally criminal behavior that has been reported to and founded by police. So they're selling drugs out of the property. You can do an expedited eviction. Those sorts of things. But just, man, this guy is a mess. You can have rules and you can cite them for violations and you have to have so many citations and those sorts of things. So you can do that, but there's a lot of paperwork up front. You can't just come to them, serve them a notice and say, you're just really messy, I don't like you.
Did you say the best process is like, instead of doing like a legal eviction, just like slide up $700 on the roof?
I can't say that's the best process because that could potentially be costly. You have to be aware that in the United States, anyone can sue anyone for anything. I'll give you an example. I've got a case where family invited her sister, yeah, come visit us. Sister brought husband. Sister and husband were fighting. They'd been there a couple weeks. They're fighting. They say, hey, you know, you said you got someplace else to go. Why don't you guys just go? Oh, okay, we'll go. Well, now they're suing him for wrongful eviction. And we've got text exchange basically saying, you said you got someplace else to go. We think it would be best if you'd just leave. And the court still we filed a motion to dismiss, and the court denied it, saying, well, with the current eviction laws, that could be a tenancy, and they would have needed to do more to evict them. And I'm like, there was no eviction. They didn't say you have to get out. They didn't serve them a paper that said, yeah, we think it would be best if you went somewhere else. To someone who wasn't paying rent. I mean, that's how crazy it's kind of gotten.
What about like personal contracts started? Just like these are the kind of rules of the house that you break if they want to break that part of it and you're out. That's a legal document, right?
No and yes. Number one, a lot of those are subjective. So with a contract, it has to be clear, definable terms. So you can't use terms like messy or difficult, or, you know, because those are, what's one person's messy is not another person's messy. So that's an open to interpretation term. You can have rules of conduct. So you can have when you can come and go, when you can have guests, when when you can use this facility, that facility, those sorts of things. You can have those rules, and if they violate those rules, you can give them a notice, and then you can put penalties, like financial penalties. And then if they don't pay the financial penalties, you evict them for non-payment. That's typically the best way to go. But you have to be very careful about what those house rules are, and are they an infringement on their rights to do something. So you can't say no guests. Well, people are allowed to have guests at their residence. You can say no overnight guests, depending on the structure, but not no guests.
And it's also the case if you live in the property as well, and it's like a roommate situation.
Doesn't matter. Yeah, no different. An eviction of a roommate is the same as an eviction of a tenant in a house, in a standalone single owner house. So all the rights that apply to that room apply anywhere else. Now there are some short-term tenancies where your hotels and stuff, where you've got an overnight contract. That's going to be a shorter tenancy. You're going to have like a 3-day notice on that. But when they've been in your house for a long time, even if they're just a room, they're presumed entitled to have a tenancy.
Yeah, on a similar note, I heard that if you're living in the property, you're not subject to fair housing laws like you typically are if you're not owner occupied. Can you expand on it?
So I'm not sure about the exception for. There's usually exceptions for less than so many people in a structure, and that's where you get fair housing. But there are some rules that are going to apply no matter what size it is, and that's discriminatory housing. That's going to apply. No matter what, you can't discriminate for protected classes. Now, the issue is, and it came up, someone asked earlier about that, how will they find out? Well, the reality is you never evaluate someone just on one factor. You're always evaluating someone on credit score, personal interview, personal references, prior landlord, rental history. I mean, there's a whole host of things you're evaluating them on. And so you can be more discriminating as far as, not towards a protected class, but just as far as who you're letting into your home, because you'd obviously want a further background check than an apartment complex and they're just renting out 100 apartments.
So I guess, not really related, but a good question of mine is like, what do you think the average person's ability to like write a legally binding contract is? Would I have everything be like reviewed by a lawyer, like detailed? Because I feel like my biggest fear is like somebody finding like a loophole, something I write, and then just like crazy stuff is happening.
So I would not recommend that anyone who's not a trained lawyer write their own lease agreement, because it always turns out badly. However, I also don't think that new investors have to go and pay someone $500 an hour, $2,500 to draft a lease for them for their one home that they're renting. That doesn't make sense either economically. There's a lot of online resources that are helpful. You want to make sure that they're Colorado specific. So So there's a happy medium. There are resources. It used to be it was either drafted your own, and I've seen a lot of those leases that are on lined paper, and they generally don't turn out well. But I've also seen like LegalZoom and other things that are pretty good. For a small business with limited resources, I honestly don't recommend going to a big firm to have all your stuff done. Like an LLC drafted, I wouldn't do that until you're making money. That's a big line item to pay for on the hope that you're going to make money. Just get something in paper first online, and then you can, things are still good, you can make changes. If things are bad, if the business isn't worth anything, then who cares if the LLC is bad? Because people are just going to walk away. It's not worth anything.
Does the same advice apply? I mean, you said leases, like offer letters, when she was mentioning, like house rule lists.
House rules and those things are going to be different. Those are going to have to be unique. You're going to have to kind of feel your way through there. I wouldn't feel comfortable drafting them, but rules and regulations, you can look at HOA rules and regulations. You can look at some of those things and phrase them that way. As far as like buy-sell agreements and all those things, the Colorado state forms are a must. I would never, ever touch a property that that they were trying to sell without a Colorado approved form. So a buy-sell agreement, disclosures, all of those things, I would use those exclusively. And that's from, your bottom, buying a little cracker box house up to $40 million property. The real estate forms are generally good. You can make additions and corrections to them, but that's a good starting point. And always get disclosures on any property you have. There was a question earlier about corporate structures. Did we get that covered?
I was going to ask you, so you said that you have if the business is not worth a lot, it's not worth doing the LLC. How much money are we talking about?
It's worth forming the LLC even when it's just an idea stage, because that solidifies what people's rights and roles are. So even if before it's brought in $1, but it's not worth paying a lot. It's not worth having your biggest expense be legal expenses to draft your documents when it's just really an idea. So that's when you want to use like a LegalZoom, a Forms Inc., those sorts of things.
How much money are we talking
To do an online one, you're probably $500 to $700 at the most. It depends on how many members and how many provisions you have. So you can make them complex, but you can also make them fairly simple.
Say, hypothetically, if the house was bought through a VA loan, would that also change if you want to build a partnership or an LLC with that house that was bought with a VA loan? Because there's some things that you need to adhere before you even.
Yeah. So VA loans are great, but they do have some restrictions on them, and where you get into problems. And I've got a case against realtors now because they didn't understand VA loans. So with your VA loan, you don't have the down payment and you get a preferred interest rate, right? So if you transfer it to an LLC, you'd want to check with your lender to see if they're going to still trigger that due on sale or not. That's going to be your primary thing. If you transfer it to an LLC that's got another member, suddenly they have an interest in your VA loan. So give you a hypothetical, two people buy a house together, one qualifies for the VA loan, the other one's just a signer on the loan, but didn't qualify for the VA loan. Well, when it goes to refinance or split the house, the non-VA loan person, if they want to keep the house, is going to get a shock of their life when they go to get an interest rate. And consequently, they may try and hold on to the VA loan. Well, the VA eligible person, you're only eligible for one loan at a time. And so you're not going to be eligible for another VA loan, which means you're not using that house because it's occupied by a VA loan, and now you're trying to find a new house. So it is tricky with a partnership and you've got one person that's got the VA eligibility and the loan. You can do assignments of those loans. You want to be careful about the assignments. You want to be an assignment to a VA eligible. The VA will let you assign those to a non-eligible person. That just means you lose your VA eligibility and it's as though they served. And that's kind of awful because then they've got a 30-year loan where they're enjoying the benefits of your VA loan, and you can't do your VA loan until that one's paid off. So VA loans do make it tricky, especially with an LLC. There's ways around it. You can have each member can have their own LLC. There's some ways to try and craft it, but it does make it more difficult to be in a partnership where one person is carrying the note and the other one is paying money towards that. You just want to make it clear, if the partnership dissolves, I get my VA, protect your VA eligibility.
What are the legal risks associated with using a hard money lender? Are there any?
Yeah, I mean, there's always risks associated with that. There's risks that they're going to call notes. They're going to be more diligent in watching over you. They're going to foreclose potentially more quickly. So there are risks there. They're not as risky as things like an installment land sales contract. That's crazy risky. I would never do installment land sales contract. It's an older thing. Fortunately, it's gone out of vogue, but it's a lot of speculation. Investors will say, you rent the house, you make payments towards rent. Don't worry, I'm counting that towards purchase, but we don't actually have a purchase agreement and you're not on the deed. And what often happens is the person then walks away and there's another there's another mortgage on the house. They stop paying that mortgage. That's where you get these people who say, well, I paid my mortgage for years, but they were actually paying someone who had a mortgage on the house and was paying the bank and then stopped paying the bank and just was taking the payments themselves. That's a common fraud. That's why you don't want to do like an installment land sales contract. You want a closing where if you're going to make payments on a house, the title's going to be in your name or in your LLC. It's not someone else is holding the title while you make payments on a house. That's a bad contract.
So with the same things that activate, like the bank calling on your note, similar to a hard money lender, like if you weren't paying them back, they would.
Oh, they'll foreclose, yeah. And right now foreclosures are taking less time than evictions. So now you have to do an eviction after you foreclose. So there's
Some
that.
people have an LLC for every house they have. Would you recommend that?
If you have multiple properties, so let's talk about what LLCs do and what they don't do. So an LLC is a fiction. We create this fiction that there's this entity out there that owns this house. And that entity has all the legal rights of a person in the United States. They can own property, they can buy, they can sell, they can sue, they can be sued. But that entity only exists as long as you comply with the corporate structures. So it has to have its own bank account. It has to have its own identity. There has to be taxes done. There has to be bookkeeping, accounting. There has to be all these things. You can't dip into that piggy bank. So if you own a house, a rental property, and your LLC owns it, the rents have to go to the LLC or to the management company, then fund the LLC, and then the LLC pays out the profits to the members of the LLC. So there's that dual layer. If you're complying with those structures, then it offers you some legal protection, meaning you can't personally be sued for acts of the LLC unless you, it's called piercing the corporate veil. You did something that pierced the corporate veil that made you have personal liability. That's why a lot of homeowners will own homes in LLCs. Now, if you own multiple homes, if you own one home with an LLC, the limit of that LLC's liability is their assets, right? If all their assets are gone, the company goes bankrupt, it's gone. It just doesn't exist anymore. It doesn't even have to file bankruptcy. It just doesn't exist anymore. You just file something with the Secretary of State saying, I have no more assets, this company's gone. So if you get sued, the limit of your liability is that house. That's your asset. If you own 15 houses with the same LLC, then the limit of your liability is 15 houses, because that LLC owns 15 houses now. And so if the lawsuit is more than one house, they can go after all your other assets that the LLC owns. That's why a lot of homeowners or renters who own multiple rentals will have an LLC for each property, because it limits their liability to that. Now, it does get complex with this LLC paying and this LLC paying and doing the books. And so you really need to make sure you have a team kind of managing your books for that, because if something bad happens, you want to make sure that it's protected and that it's isolated from your personal home, from your other homes, those sorts of things.
And LLCs are the superior, like, legal entity for this purpose?
It depends. LLCs are the easiest to form and they have what's called pass-through taxation. So LLCs aren't taxed. They're treated as an S corp by the IRS, which means that the members get taxed on what the LLC makes. So it's pass-through taxation. So you get a K-1 rather than you get, a W-9 or W-2 or whatever. So it's a tax thing that makes it different than a C corp or an S corp. A C corp has stock certificates. It's an actual corporation like Coca-Cola and those sorts of things, where you can buy stock in it. It doesn't have to be an open corporation. It can be a closed corporation. But LLCs are cheaper and easier to form. So yes, that's generally why they're preferred for this.
Are there any, like, cheat the system tax things I should be aware of?
I don't do taxes, so I always refer people to get a good accountant and make sure they're doing your books. And if you have different LLCs, make sure they're keeping different books for each LLC. Because a lot of people will have an LLC that's their management company and then an LLC that owns each one of their properties. The properties pay the management company pays the expenses, then the profits go to the members. And so it's kind of a too deep layer. Now that's great if you own 15 properties. If you own one house, it doesn't make sense to have a management company and an LLC.
Yeah, are there any pitfalls to be aware of with that sort of scenario? That's what we have, like 6 properties, and then the management company that most has through, but yet serve those 6 type
Yeah.
properties.
So what you really want to be careful for is that you're not piercing the corporate veil, so that you are an officer or employee, that you're getting paid for what you do, or you're taking your dividends or your annual draws. Where people get into trouble is they start taking draws. Well, I need a monthly draw because I've got bills I got to pay monthly. Well, if you're taking monthly draws, you got to make sure that there's the money's there. Otherwise, you're just dipping into the piggy bank. So that's what you've got to be aware of with LLCs. Is it does work to have a management company, but you've got to keep those structures. It's got to be, okay, who owns the truck? Is the truck owned by the LLC? Okay, then the LLC's got to pay the taxes, the insurance, everything's got to be through that. And you're going to pay higher insurance as an LLC than you would as a private individual, but it's something you got to suck up if you're going to get the benefits.
Does that 2-step structure provide some legal protection as far as, like, instead of owning the property in the LLC and renting it from the LLC and all that, instead the management company is paying the tenant?
Yeah.
So, like, if there was slip and fall or I don't know, something management related, they would sue the management company now that has close to zero assets, or much closer to zero than
Yeah.
this entity that owns a $500,000 house.
They're going to sue both the house and the assets. So they're going to cover both the property. That's one of the hazards of owning property is it's always easy to figure out to sue the property because you always have jurisdiction, right? You're always in the right jurisdiction. If it's the jurisdiction where the house is, you're in the right place. And so they're always going to add the house and then the management company. Does it have some, okay, well, who was really liable and there's an apportionment of liability? Could you apportion the liability? Yes. And they might say, oh, the management company was 90% liable for this. The owner of the house was only 10%. Okay, well, the management company doesn't have anything, so they're not going to pay.
Okay, yeah, so would it be looked at different if, because I mean, in this case, like, I'm the owner of the management company and of the entity that owns the property.
Yes.
So would it be looked at differently? Is that easier to attack against the property versus if it was a third-party management company and then I own the property? Or is it looked at the same? Like
It's going to be looked at the same as long as you're keeping the structures as that management company that you're the member manager of. You're a member in an LLC, and you're an owner of a company. But as long as you're keeping those structures fine, then that's fine. But that means you're going to have to, you're going to have to be careful if you're working on the property. How are you working on the property? If you're shoveling snow, are you shoveling snow as a manager? Or are you shoveling snow as an owner? Or are you shoveling snow as a LLC member? That's the real where it gets tricky. If you're hiring people to do all that and you're kind of turnkey, then you're just writing the checks. You just got to make sure they come out of the right account.
What common legal issues, like arrive during the closing process?
So there's not a lot that arrive during the closing process. A lot of states require attorneys to be present at closing. Colorado is not one of them, and thankfully, because that's boring. The title companies do most of the documentation, and they do, for the most part, a great job. So they'll do your title commitment. The problems don't happen at closing. Problems happen 15 months later when people actually read the documents or actually go to the property. And the problem is, so title insurance is an insurance policy that you buy that says what you paid for is what you get. But they have a whole host of exceptions up front. And one of those is like unrecorded easements. So I've seen this happen, unfortunately, multiple times, where people buy a property and they don't go out there instantly, or they go out there and they see fences and stuff, and they're like, okay, yeah, this is the property I own. Well, it turns out that's not really what they own. Their fence line is actually 10 feet this way, 10 feet that way, 10 feet the other way, but the other neighbors have kind of moved it in, and it's called adverse possession, where they've stolen your property. Title insurance isn't going to do anything about that because it's open and notorious. They're actively stealing your property. I had one case where a guy built a shed on his neighbor's property. And when they got a survey, they're like, did you know your shed's on our property? He's like, yeah, I knew, but I didn't think you'd figure it out. So they're like, okay, you got to move. So he had to move his shed. And fortunately, he had built it on stilts because he knew someday he may have to move it. So he just dragged it back onto his property. But title insurance covers most of the defects that you're going to find as long as you do your homework. The HOA covenants. A lot of people have problems with their HOAs. Problem is the covenants are published. They're open. You're expected to know what they are before you buy the house. Covenants that run with the land, those are different than HOA covenants. So a covenant that runs with the land, it could be no business is operated on this property. It's purely residential. Well, that was probably made in the 60s or 70s when a business was a big building that people went to downtown. Does that mean you can't sell Etsy stuff out of your house? Maybe. It depends. So those are the things that come up after closing. But at closing itself, I mean, if the loan's going to fund, an attorney's not going to help you with if the loan's not going to fund. If the title work is good, if the title works, if there's a problem, they won't go to closing. Just back off. Don't say, oh, there's a problem with title, but we'll fix it after. No, I want that fixed before I own the property. Because as a buyer, you have all the power in the world until you pay your money. And then you have nothing. You've got whatever they gave you. So you retain the power as long as you retain your money.
Okay, time for one more question. Don't have one.
I know you said you don't do taxes, so this might go to somebody else, but, my question is, how can you use 1031 exchanges to, take advantage of them to defer on taxes on property sales?
Yeah, I don't do 1031 exchanges because they are tricky. It's taking one property, exchanging it for another property in order to avoid some tax liability. Taxes will always get you in the end. So you can't, no one escapes death and taxes. So
Is there any additional risk in buying a for sale home?
there's not. They can be a great deal. You want to make sure that you're using Colorado approved forms and that you're getting full disclosures. So a large number of cases are failure to disclose. The basement was cracked, they didn't tell me. The roof leaked, they didn't tell me. Those extend beyond the life of your contract. So even when you take possession, you still have to, those disclosures are still there. It is, but there's disclosures that are mandatory. So as long as you use the Colorado real estate form and the disclosures, they cover almost everything. And the seller has to check yes or no, and then gives a description. So does the roof, are there problems with the roof? Yes or no? Yeah, you don't, you get what you get. And there is no liability for a seller if it's sold as is with no disclosures, as is.
All right, give it through. All right, guys, thank you so much for coming out. We have about an hour left of networking. So if you want to talk more, if you have some more personal questions for Bruce, Jim Wayne, already heading out here soon.